Thank you, Ms. Reynolds. Ms. Mailman, you're next. You may begin. Push that button for me.
I'm May Mailman, Senior Fellow with the Independent Women's Law Center, the legal advocacy arm of Independent Women's Forum and Independent Women's Voice. I am also a mother to my 8-month-old daughter. I am testifying here today in support of her future, her freedom, and her equal opportunity. My fellow panelists have covered the pernicious effects of gender ideology on children and their futures. I'm here to address another way in which gender ideology destroys women and girls, and that is by dissolving legal protections for women in athletics. Until recently, female student athletes might have thought that they were protected by Title IX of the Education Amendments of 1972, and they were. That's because Title IX is very simple. It prohibits discrimination on the basis of sex in programs run by schools that accept federal money, and that's basically all of them. And those programs include sports. Title IX recognizes that providing equal opportunity for the sexes can mean recognizing inherent differences between the sexes. That's why the Title IX statute explicitly allows schools to provide different living arrangements for the sexes. So too in sports. In introducing Title IX, Senator Birch Bayh explained that Title IX would not require sticking women on men's football teams. And that's why Congress explicitly asked that the initial Title IX regulations include reasonable provisions considering the nature of particular sports. And so for 50 years, the Title IX athletics regulation has explicitly permitted sex-based teams where selections for such teams is based on competitive skill or involves a contact sport. Importantly, the regulations also require that schools must provide equal opportunities for members of both sexes. Unfortunately, in April of this year, the Department of Education proposed a rule that, if adopted, would flip Title IX on its head. The proposed rule would modify the athletic regulation to let schools compete on teams consistent with their gender identity unless a particular school can demonstrate to the satisfaction of the Department of Education that this policy would be too unfair or unsafe. In other words, women are no longer granted female sports teams as a given. We have to prove that we need it. Of course, we do need it. Studies show that even testosterone suppression cannot eliminate the male advantage. Except schools are not going to be allowed to say that as a general matter, post-pubescent biological males playing women's sports puts female athletes at risk of injury and losing playing time, medals, and privacy. No, schools are going to have to prove to federal bureaucrats that allowing a biological male on a woman's team would be unfair or unsafe in this particular sport with respect to these particular athletes. No school is going to want to take on that litigation risk, and so schools are going to allow biological males to compete on women's sports. This will directly and overwhelmingly harm female athletes who are far more likely to be displaced by a male athlete than vice versa, and far more likely to face risks in private spaces like locker rooms. And even if it were a good idea to reduce educational opportunities for women like this, the Department of Education may not do so unless this body has authorized it. But Congress has done no such thing. The Department of Education says that the Supreme Court's decision in Bostick versus Clayton County means it can pretend that Title IX addresses gender identity. But the Department of Education is wrong. In Bostick, the Supreme Court said that Title VII of the Civil Rights Act prohibits employers from firing someone just because they are transgender. The decision says that an employee's sex is not relevant to the selection, evaluation, or compensation of employees. Athletics and education, however, is governed by a different law, Title IX. And when it comes to athletics, sex is not only relevant, it is often dispositive. As superstar Serena Williams said, men's and women's tennis are completely different sports. We live in a nation of laws and not bureaucratic command. That means the Department of Education must find its authorities in the laws that this legislative body has considered and passed. It may not use gender ideology to twist a simple anti-discrimination statute. into a statute that reduces opportunities for women. Thank you.
Thank you, Ms. Mailman. Mr. Minter, now you may begin.
Thank you. My name is Shannon Minter. I'm the legal director of NCLR. It's a legal organization that represents LGBTQ people. I'm at 30 years with NCLR, 20 years as its legal director. I've represented many transgender young people in cases involving discrimination and harassment in schools, in the child welfare system, the healthcare system, other areas. Recently, I've been involved in federal challenges to state laws that ban medical care for transgender young people and completely ban them from school sports. I really appreciate the opportunity to address this committee. You know, parents should have the freedom to make health care decisions for their transgender children. Parents want what's best for their children. Americans differ about a lot of things, but there is one point on which we strongly agree, and that is that parents, not the government, are best situated to make medical decisions for their own children. There's a lot of misinformation about transgender children, youth and adolescents. Gender dysphoria is very rare, less than 1% of the population. Most people in this country don't know a transgender person, much less have they met parents with transgender children. For most people, most legislators, this seems like a new issue, but medical care for transgender adolescents has been available for more than 20 years. The very same medications being prescribed for transgender youth have been prescribed for other young people for other conditions for more than 40 years. There is a substantial body of research that shows these treatments work. They improve mental health outcomes, quality of life, social relationships, family relationships. They dramatically reduce suicidality. One federal judge, after a full trial, said there is now extensive clinical evidence showing excellent results for these treatments. The medical standards for these treatments, as has been noted, have been endorsed by every major medical association in this country: American Medical Association, American Academy of Pediatrics, American Psychological Association, many more. These standards, they're evidence-based. They require a rigorous multidisciplinary assessment before diagnosing a child with gender dysphoria. They take a conservative approach to treatment. Those standards have been in place for a long time. They are not new. What is new is this recent massive overreach by state lawmakers to ban medical care for transgender youth. These laws, these recently passed state laws, they prevent doctors from doing their job. They prevent parents from getting the medical care that their children need. And that is why every federal district court, all 6 of them, after hearing all of the evidence, have concluded these bans violate parents' rights, they violate equal protection, and the claims they put forward to justify the bans have no basis. These decisions, as has been noted, have been issued by a wide range of judges: Arkansas, Alabama, Florida, Indiana, Kentucky, Tennessee. In every case, the state officials supporting these bans had every opportunity to back up their false claims with actual evidence. Each case, they have failed. These bans pose a serious threat to the health and safety of transgender young people across the country, and I urge the members of this committee to reject any federal attempts to replicate that harm. As a transgender person myself, I have benefited from decades of access to health care, legal equality, support, been able to marry, have a family, pursue a career, participate in my local church and community. It is very disheartening to see the protections that have given me and other transgender people so many opportunities to thrive and to succeed now just being needlessly taken away from young people. Healthcare bans conflict with medical expertise. They rob parents of their right to make medical decisions for their children. They have devastating consequences for young people's lives. Decisions about children's medical care should be made by the parents who love them, not by politicians who know nothing about a child's life or history or circumstances, and who won't be the ones having to watch a young person they love suffer the devastating consequences of going without needed medical care. Thank you.
Thank you, Mr. Minter. And Dr. Bowens, last but not least, you may begin.
Chairman Johnson, Ranking Member Scanlon, and members of the subcommittee, thank you for the opportunity to speak with you today. My name is Dr. Jennifer Bowens, and I'm a licensed therapist, clinical researcher, currently serving as the director of the Center for Family Studies at Family Research Council. Based on over 25 years of experience as a clinician providing trauma therapy to children and as a researcher investigating the psychological effects of traumatic stress, I'm here to express my concern about what has been termed gender-affirming care. I've considered it a privilege to practice, research, and train future clinicians and be a part of a discipline aimed at protecting and bringing healing to the most vulnerable in our society, which are children. But when it comes to gender transition procedures, my field is not operating as a helping profession. Instead, it is actively causing harm. Historically, children have been treated as a special and vulnerable class in the psychological and research fields. Caution has been applied to children in light of the fact that they do not have the neurological capacity to understand lifelong decisions. Professional and research ethics tell us that we should proceed very cautiously with regard to interventions for children when empirical evidence is weak or the research methods are in the early phase, as with this case. We should avoid interventions that pose unnecessary risks, particularly when the symptoms are known to change with maturation. But risk avoidance is not what's happening with gender transition procedures. Instead, we have too many cases like Mike. Mike was 9 years old when he first saw a gender therapist. I was deeply saddened when I read his gender therapist case notes, where it was reported that Mike couldn't distinguish between fantasy and reality. Instead of investigating these symptoms, the therapist wrote in the treatment plan, which included puberty blockers, guidance on social transition, and education for future hormonal and surgical procedures. This treatment plan was enacted without regard for this child's known diagnoses of autism, possible OCD, and possible parental diagnoses, which were reported in the case notes. Mike is just one example of how so-called gender-affirming care is in direct opposition of our knowledge regarding development and our understanding of good research and treatment. And there are many reasons why I have concerns, but I'll just share a few with you. One, these interventions are being endorsed based on consensus, not evidence. In the case of gender-affirming care, the term evidence-based does not mean that this practice is standing on the merits of solid research findings addressing gender dysphoria. Instead, it refers to a vote by those who are ideological supporters of the practice. Compared to other psychological disorders found in the DSM-5 TR, gender dysphoria is currently being treated with the most invasive interventions connected to a psychological issue with the lowest quality of evidence to support that practice. And two, the success rates of non-intervention for gender dysphoria for children already exceed what most psychological interventions have. In most cases, 85% or more of those experiencing gender dysphoria will desist if they are left alone. This is a higher rate than most well-established and researched psychological interventions, and with success rates this high, it is actually unethical to intervene. Three, the research and practice around this issue does not properly account for competing diagnoses and variables. So in one example, a report from the UCLA Williams Institute found that 45% of transgender identifying people reported childhood sexual abuse. As a trauma clinician, I can tell you that when someone experiences sexual trauma, it is not uncommon for that person to hate parts of their body or want to get rid of those aspects of themselves that made them vulnerable to abuse. And four, it is often claimed that a failure to provide these interventions increases the risk for suicide. This approach is actually unethical, and it's a clear departure from the practice of empowerment and self-management, which are important goals of mental health practice. This claim is also not supported by the literature. Despite years of empirical study, there is no definitive understanding of the etiology in the suicide literature. Five, after a review of the literature, other countries have actually backed away from gender transition procedures, and the list now includes the United Kingdom, France, Finland, Norway, Australia, and Sweden. And six, last, gendered affirming care has created a monopoly on treatment options, as it demands that it is the only way to treat gender dysphoria. By comparison, we can look at Cochrane collaboration, for example. There are 245 meta-analytic reviews of varied treatment options for depression. Yet when it comes to gender dysphoria, there's only one path currently prescribed to help someone, and that's to become someone else. Researchers and clinicians should be innovating solutions to heal distress, not coercing kids onto a path that tells them that they need to remove or change physical parts of who they are in order to be whole. This is why I'm calling on you to act on behalf of children.